You said that you called 911. How long after this happening did you call 911?
Like just after that.
Immediately after?
Yeah.
And did an ambulance come?
Yeah.
And did the ambulance take you to the hospital?
Yeah.
Which hospital did you go to?
Sparrow.
And how long were you at Sparrow Hospital?
About 12 hours or so.
And what sort of treatment did you undergo when you were at Sparrow Hospital?
Then blood work, CAT scans, MRI, and they patched the wound up with something called Durabond. It's like a medical glove. And
And how long were you experiencing pain in your Did it leave a scar?
yes,
Is the scar still there?
yes,
When you were at Sparrow Hospital, did you speak to the police?
yes. They came multiple times.
So independently, people propose exhibits 1A and 1B. Your Honor, may I approach the witness?
Yes.
Approaching the witness, the people propose exhibits 1A, 1B. Just take a look at each and you recognize these, okay? You recognize that?
Yes.
Now, this is 1B. You recognize that?
No.
No, you don't recognize that.
The courtroom opens with routine questions, but the real strategy starts long before the difficult testimony arrives. Every instruction about speaking clearly and answering directly serves a legal purpose. Precision matters because every word becomes part of the permanent record, and vague answers can change how evidence is interpreted later.
So just focusing on 1A, what did we see in exhibit 1A?
That's medical.
And where were you when that photograph was taken?
Sparrow Hospital.
You remember who took that photograph?
I think the police did, but I'm not sure.
And was that picture taken shortly after the stabbing happened?
Yes, because the outfit I had on, they ended up cutting it off.
In that picture, is that a fair and accurate depiction of what the wound looked like? Your Honor, the people move to admit exhibit 1A.
Objection, Your Honor, like foundation.
When I submitted.
Not publishing exhibit 1A. Actually, share this time. Now, right here where my cursor is that where he stabbed you?
Yes.
Now, since that September 11th date, did you have any contact with Mr. Silva after that date?
I'm sorry, what?
Did you have any, this way. Since that stabbing, has Mr. Silva assaulted you again?
Objection, Your Honor, that's leading.
It's not, it's a yes or no answer. Overruled.
There was another incident afterwards,
Okay.
but it was multiple people involved,
Okay,
and
so we'll just start here. That 608 West Willow apartment 412, were you there on
after,
F12, sorry. Were you there on October 10th of 2024?
yes,
And in case you didn't say this already, is that building in the city of Lansing?
yes,
Is it in Union County?
yes,
And also, I apologize, I should have done this sooner, but do you see Mr. Silva in the courtroom right now?
yes.
Could you please tell me where he's sitting and identify something he's wearing? Your Honor, could the record reflect that witnesses identified the defendant?
Any objection, Mr. Sarks?
No objection, Your Honor. Thank you.
The record will reflect ID.
Now, when you were in apartment F12 on October 10th, who all was in the apartment with you?
It was me, Shafton, girl named Lisa, girl named Justin, girl named Jason. And Lisa's two kids.
What was the last thing you said after Jason?
Lisa's two kids.
Oh, Lisa's kids, gotcha.
And then did there come a time when
Once the witness begins describing a relationship that stretched across many years, the prosecution quietly builds credibility before ever addressing the alleged assault. That approach gives the court context instead of isolated facts. Notice how memory becomes an unexpected issue almost immediately.
the defendant began behaving erratically?
Yes.
Can you tell me a little bit about how he was acting that was unusual?
Well, he just wasn't himself, like, he was like hearing voices and he was getting like really upset, and I was trying to calm him down. And then a couple other people were like really not helping the situation. They were like kind of like antagonizing like the issue.
So he was worked up, you indicated he was hearing voices,
Yeah,
and you tried to calm him down, and then other people were kind of antagonizing him?
yeah.
And did you eventually see or hear anything that made you think something physically was wrong?
I actually, I heard verbal altercation between him and I think it was Justin.
Him as in Shafton?
Yes. However, I was in the bathroom and I came out the bathroom because I heard my front door open and I'm like, okay, who's out yelling with my door? And then I went out there and Lisa's out in the hallway. No, I take that back, I'm sorry. Justin is out in the hallway. Lisa was by the door. Shafton was like in the apartment. And Shafton and Lisa were like all in an uproar and I'm trying to figure out what's going on. And next thing I know, I got punched. I don't know who it was, to be honest, because I was in the middle of like everything at the time.
Did you see the defendant swinging at anybody else? Now you indicated that you got punched. Was this open hand or closed fist?
I don't know. I just saw something in my head right here. I do know I was facing Lisa and Justin. Schachenhauer was behind me.
Okay.
So, and in the midst of everything, I don't know what happened.
And then did you or someone else wind up talking to the police about what happened?
Lisa called the police, and when they showed up, I obviously spoke to them. It was fine. I'm hurt.
Do you remember talking to Officer Carter Harold,
I don't know who it was.
but you remember speaking to a police officer?
Yes, vaguely.
You remember telling the police officer that, you remember telling the police officer that Shafton hit you in the head?
No. I remember saying somebody did. I don't remember saying that it was him because I didn't know who it was.
If you were to take a look at Officer Hill's report, would that refresh your memory of whether you said that Shafton hit you?
I think
Possibly, I
it's
don't know.
unclear on the record whether she's denying saying it or whether she's saying she doesn't remember.
Okay. So let me just clarify, is it your testimony today that you did not say it or that you don't remember if you said it?
I don't think that's what I said. No, I don't recall saying that.
The cross-examination shifts the courtroom away from emotion and toward uncertainty. Defense attorneys rarely need to prove an entirely different version of events. Their objective is often much simpler. Introduce enough doubt that the prosecution's narrative loses its certainty.
Did you have any sort of ongoing pain or any sort of injuries after that? Don't have any additional questions for the witness.
Cross-examination.
Thank you, Your Honor. Ms. Berkeley, I just have a few follow-up questions for you, okay?
Okay.
You testified earlier that on October 10th or October 11th, that you mentioned that Mr. Silva appeared to be hearing voices, correct?
Yeah.
Okay, could you elaborate and then could you explain what that means to you?
He was like, he would be talking as if he was talking to somebody, but it wasn't talking to anybody that was physically around. It would be like he was having a conversation with somebody else, but nobody else was there.
Okay. And you've known him for a long time.
Yeah.
And you know his history of mental health very well, correct?
Yes.
So to the best of your knowledge, personal knowledge only,
Yeah.
what does Mr. Silva suffer from?
Schizophrenia.
Schizophrenia?
Yeah.
Anything else? Okay. And just based on your own personal knowledge, was Mr. Silva medicated? Had he been following up with his medications around that period of time?
No.
And how about back on September? Around September 11th, 2024.
I'm gonna check. We don't really have enough foundation to establish her personal knowledge of whether he's taking his medication.
Not a problem, Your Honor. I can ask some follow-up questions.
Please do.
Thank you. So going back to around September 10th or September 11th,
Are you
2000.
asking if he was on medication back then?
Yeah,
No, he wasn't.
he was not.
No.
And back around September 10th or September 11th, What was his mental health at that time?
It was not good at all.
Not good at all. What does that mean?
Like he was hearing the voices really bad. He would get to where like, I feel like he would have conversations, but it wouldn't be with the person that was physically there.
You mentioned that for the
He-
October date. Are you saying that was also true in September, the date he
Yeah.
stabbed you? So the
Yes.
whole time?
Yeah,
Okay, and was he showing signs possibly of paranoia too?
yes, absolutely.
Okay, describe to us what symptoms he was showing in terms of paranoia.
He would like think like everybody like was trying to get him. Like people were like trying to harm him. People were trying to harm him. Or like just try to get to him. And I would, reassure him that, hey, it's just me, nobody else is here, everything's okay. But well, in my opinion, he was so far in the paranoia that it wasn't clicking, like.
So, in your opinion, in terms of his state of mind, do you think he did it intentionally?
No, I did not.
Objection, that's calling for speculation.
Yeah, Mr. Sartz, that's not a proper question for this witness. That answer is stricken from the record.
Thank you, Your Honor. So, back on September 10th or September 11th, what did you observe about Mr. Silva's demeanor, about his mannerisms, and what was going on with what he could observe in terms of him personally?
I think you already asked that
He was
question.
sitting there, like, talking, like, he was talking.
Hold on. You asked that question. She already said he was having conversations with people who weren't there and that he was acting paranoid, as she described, felt like people were out to get him. Mr. Sartz, you're asking the same question again. If there's something else you would like her to describe, ask that question.
I'll move on, Your Honor. Thank you. And
Questions about another incident, multiple people being present, and confusion during the confrontation all work toward that goal. Instead of attacking every statement directly, the defense highlights moments where the witness admits she cannot confidently identify every action or every person involved.
you had been working with him in terms of these symptoms even before September 10th, correct? And he had been displaying those types of behaviors for approximately how much longer?
About 2 months.
Good.
It
And
just progressively got worse.
progressively got worse. Okay. And had you observed him when he was on his medication?
Yes,
Okay. And when he was medicated, he would not act out in that way, correct?
correct.
Okay.
He was very like high functioning member of society, He was a good person and he's on his medication, absolutely.
Okay. So you could see a clear deterioration from when he was on his medication versus when he was off. his medication.
Absolutely, yes.
Okay. And he was very clearly off his medication around
Very.
September 10th, September 11th, and, okay, and he'd stopped taking his medication a few months prior, correct?
Yeah.
Okay. And do you know why he stopped taking his medications?
I do not know.
Okay. He was indigent at the time, right? He was struggling to get access to care.
Yes, he was, yes.
Yeah, he was struggling to get access to care through CMH at that.
Yes,
In
it was,
September.
and I was helping him as well, trying to get into contact with somebody with CMH so that he could get medication and counseling and things that he needed for his mental health.
Okay, thank you for that. And he had the same struggles with them in October.
Objection,
correct?
we're we're going so far outside the scope of what this witness can testify to regarding his mental health and his treatment.
Your objection was late, and Mr. Sartz, you're characterizing some of these things in a way that I don't think is proper for you to ask the question. You can ask her if she was assisting him by calling community mental health or taking him there. But some of the other questions you're asking are not appropriate and will not be considered by the court.
Thank you, Your Honor. Sure. Did you assist him in any way, shape, or form in terms of his mental health?
Yes.
Okay, what did you do?
I would call, reach out to CMH, and I got a number to somebody he worked with before from CMH, from his mom, and his tried to get him a primary care doctor as well.
Okay. And did Mr. Silva participate with you when you were making these efforts?
Yes.
Okay. No further questions, Your Honor. Thank you.
Redirect?
No redirect, Your Honor.
All right, you may step down, Mr. Berkeley. Mr. Marchman, any additional witnesses?
Yes, we're going to call Zach Vanderwerf.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes, ma'am.
Okay, have a seat. Please keep your voice up so I can hear you around the plexiglass and answer with words that we can actually type, like yes or no. Start with stating your first and last name and last name and spell them both, please.
Yeah, my first name is Zachariah. That's Zachariah. Last name is Vanderwerf. That's Vander, capital WERF.
Thank you. Your questions for witness Vanderwerf.
Yes, first I would like to briefly make a record of something. I just spoke with one of our victim advocates who was here during the first witness's testimony, and she indicated that she saw the defendant mouthing words to the victim or the witness and saw her looking at him and kind of acknowledging that he was mouthing words to her. And I would like to let the court know that after Zachariah Vanderwerf testifies, I do plan to call her as a witness to testify about what she observed during the sort of recanting testimony.
We started late and I need to leave, so let's finish this witness and we'll see where we end up.
Okay. Officer Vanderwerf, how are you employed?
I'm employed with the City of Lansing with the Police Department.
And how long have you been employed in that capacity?
It's coming in February. It'll be 9 years.
And what is your role with Lansing Police Department?
I'm a road patrol officer, so we respond to 911 calls.
And were you working on September 11th of 2024?
I was.
And did you respond to a call that took you to Sparrow Hospital?
Yes.
What was the nature of this call?
So the nature of the call was reported as a stabbing.
And when you were there, did you make contact with someone named Stephanie Berkeley?
Yes.
And did you wind up taking a statement from Stephanie Berkeley?
I did.
The redirect examination changes the battlefield completely. Instead of focusing only on physical events, attention turns toward mental health and whether it explains the defendant's behavior. That is a major strategic shift because it influences intent without directly arguing guilt or innocence.
And when you took the statement, were you wearing a police uniform?
I was.
And did you identify yourself as a police officer?
No, I don't believe I identified myself as a police officer, but I was wearing the uniform.
It was clear you were a police officer.
Yes.
And did she describe having some sort of relationship with Shatton Silva?
Yes.
What did she say her relationship to Shatton Silva was?
She said that she and Silva had been dating.
And did she indicate whether she was in the hospital as a result of something that Mr. Silva did?
Yes.
And did she describe this as being some sort of assault?
Yes.
And did she tell you how much time had elapsed between?
Your Honor, we're getting into hearsay, and I'm just going to state my objections because it's apparent that the prosecutor wants to bring this in under 76827C. I would note, Your Honor, lack of foundation. The complaining witness has already testified, so the testimony is largely duplicative at this point. We've already heard directly from the complaining witness in terms of her testimony regarding the events on that date. So at this point, Your Honor, it would be arguably improper impeachment or perhaps an attempt to bolster or the complaining witness's testimony in some way. I just don't see the point in this officer potentially testifying to a statement after the complaining witness has already testified pursuant to 768-2076. Thank you.
Which means attempting to lay the foundation, and so any hearsay would be conditionally admitted on the foundation being laid. The statute does not say that just because the witness did testify that we can't accept the testimony, but I would agree that it could be duplicative. Mr. Marchmina, I did not believe that you were going to call this witness to reiterate everything that Ms. I can't remember at the moment. Ms. Berkeley said, but only because maybe you were trying to get in that exhibit that didn't come in.
Yes, and certain statements she did not remember.
If they don't add to the elements, you're just wasting time.
Did she indicate how much time had elapsed between the assault and you taking, you speaking with her?
I don't recall.
Did she indicate whether it was earlier that day, whether it had been a week?
I don't recall that either.
Okay, we'll move past that. Did you observe any sort of injuries
Yes,
on Ms. Silva?
yes, I did.
Could you please describe what you observed?
So what I observed to be what looked like a stab wound to the middle left part of her back. And then I also observed what looked like an abrasion to the right side of her forehead.
Showing defense table people's proposed 1B again. Your Honor, may I approach the witness?
Yes.
Exhibit 1B. Do you recognize 1B?
Yes,
What is that? What is 1B?
that's a photograph of the abrasion to her right forehead that I took.
And is that a fair and accurate depiction of the abrasion on her right forehead?
Yes,
Your Honor, people move to admit proposed exhibit 1B.
No objection, Your Honor.
1B is admitted.
Now publishing 1B. And is this the abrasion on her forehead that you were describing?
yes.
No further questions.
Cross-examination.
None, Your Honor. Thank you.
All right, you may step down, Mr. Greenberg.
Thank you, ma'am.
Mr. Marchmina, what is the purpose of calling the victim advocate as a witness during the prelim?
I have well, because we are going to need to request a continuance to have 27C testimony regarding the second file because she obviously recanted. And I have a suspicion that there's going to be arguments regarding the
arrival of the responding officer transforms the hearing from personal recollection into independent corroboration. Unlike the earlier witness, the officer has no emotional history with either party, giving the court a different type of evidence to evaluate.
admissibility and credibility of the 27C testimony. And I do believe that an advocate saying that he was trying to communicate her while she was testifying would certainly reduce the credibility of her recant and increase the credibility of her initial statement.
In light of the fact that we have to return another day for you to get an additional witness, can we do that at that time?
Yes, we
So you have a motion to adjourn primarily regarding 3098.
Yes, we are prepared for bind over on 2734, but it obviously
ran
makes no
them-
sense to bind over on one and then,
Well, just because we chose to run the exams simultaneously, I don't think I can split them now at this point.
yeah, and there's no point in splitting them, so.
All right, Mr. Sarts, do you want to respond to the motion to adjourn?
Thank you, Your Honor. Mr. Silva, to preserve the issue, would object to any request for an adjournment. Mr. Silva at this point would request that the other count be dismissed, obviously based on the lack of testimony from the complaining witness. The prosecutor wants to claim it's a recantation. The bottom line is she made it very clear she couldn't remember what allegedly happened and what the source was of her injury. So I would classify that as a recantation respectfully. It's just a disagreement in terms of proofs, but the bottom line is they don't have any supporting evidence right now directly from the complaining witness that would support buying over on that charge, at least based on her testimony today. So respectfully, Your Honor, to preserve the issue, I just request that matter be dismissed. Mr. Silva would like me to respond on both files if Your Honor would be permit me to do so. Thank you.
As to the issue of presenting a witness or presenting an additional witness after the complainant has recanted, 768.27C allows that hearsay testimony to come in as substantive, so not merely as impeachment. And since it's allowed to come in as substantive, I do believe the prosecutor can call an additional witness to present that evidence. So the motion to adjourn is granted one time only. The files are getting old, although a lot of them being old is his time spent at the forensic center. We're going to get a new date right now. You said January 2nd? January 2nd, 10 a.m. Mr. Sartz on bond.
Thank you, Your Honor. Mr. Silva would respectfully request a low cash assurity or personal recognizance bond at this time on both of these files. These cases are quite old at this point, and that is attributable, of course, to Mr. Silva's journey in terms of the mental health side of things. He was found incompetent to stand trial. He did spend time at the psych hospital down in Kalamazoo. But at this point, Your Honor, he would request an opportunity to be released. He would have a safe place to potentially stay. He's been receiving very good medical care for his mental health as well. You know, he's of a clear mind now. He has a very good understanding as to where he's at, what's going on, and he is back in connection with important people for his mental health care. So if he was released, Your Honor, he could follow up with CMH. He'd like the opportunity to potentially work again. When he is on his medications, Your Honor, he can be a very productive, very good person. And it's just and he has access to his care again. So respectfully, I would just ask for a reduction to a personal recognizance or low cash assurity bond at this time. Thank you.
Mr. Martin, do you wish to respond?
Yes, I have two people in the back who could come out and say that they saw him violating the no contact order right in court. So, and then lo and behold, the witness recanted. So I would obviously suggest that he can't be trusted not to try to impact the testimony. Obviously, the second offense was alleged to have occurred while on bond for the first offense. And he's competent now, but Mr. Sarge, with the listening testimony, he clearly was attempting to establish these happened because he was not on his medications. And I don't know how we can trust that he will be on his medications when not in custody. So for all those reasons, I would post
Thank you. The testimony the court has heard so far has been about a very serious assault that involved a stabbing. I don't know if the prosecution intends to move to amend the charge to a more serious charge, but there's that. There's also a habitual offender notice. There's a third offense domestic violence notice, which indicates Mr. Silva has been assaulted in the past and also has had other criminal offenses. Lastly, there's a pending bond violation for being arrested and not just for assaulting Ms. Berkeley, which I understand. She says she doesn't remember. She doesn't say he didn't do it. She says she did not remember him doing it. To go with the fact that he shouldn't have even been in her presence on that day. The motion for reduced bond are denied.
The prosecution answers by shifting the conversation back to public safety and courtroom integrity. Instead of debating diagnosis or treatment, the focus becomes compliance, reliability, and trust. Allegations that the defendant attempted to communicate with the witness during testimony immediately strengthen the argument that release could create additional risks. Prosecutors also connect the pending charges, prior bond status, and criminal history into a single narrative suggesting that supervision alone may not adequately protect the judicial process. The judge evaluates those concerns through a practical lens rather than an emotional one. Serious allegations, potential witness influence, prior legal history, and unresolved questions surrounding compliance collectively outweigh the defense's request for reduced bond. This decision reflects the court's responsibility to preserve both community safety and the integrity of future proceedings while the criminal case continues moving toward trial. The hearing closes without dramatic speeches, yet the final ruling carries significant consequences. Bond remains denied, a future court date is scheduled, and the legal battle moves into its next phase without resolving the ultimate question of criminal responsibility. What stands out most is how the judge consistently separates emotion from procedure throughout the proceeding. Credibility disputes remain open, additional testimony is still expected, and several factual questions have yet to receive definitive answers. That measured approach demonstrates why preliminary hearings rarely provide complete resolutions. Their purpose is to determine whether enough legally admissible evidence exists to justify continuing the prosecution, not to decide guilt beyond a reasonable doubt. By ending with unresolved issues instead of sweeping conclusions, the court preserves the fairness of the process while ensuring that future proceedings will be decided on a fuller evidentiary record rather than incomplete testimony alone.